الحمد لله رب العالمين حمدا يوافي نعمه ويدافع نقمه ويكافئ مزيده. فيا رب لك الحمد حتى ترضى، ولك الحمد بعد الرضا، لك الحمد كما ينبغي لجلال وجهك ولعظيم سلطانك. سبحانك لا نحصي ثناء عليك أنت كما أثنيت على نفسك. فاللهم أخرجنا من ظلمات الوهم وأكرمنا بنور الفهم، وافتح علينا بمعرفة العلم، وسهل أخلاقنا بالحلم، واجعلنا مما يستمعون القول فيتبعون أحسنه. اللهم اجعل أعمالنا خالصة لوجهك ولا تجعل فيها حظا لغيرك يا مقلب القلوب، ثبت قلوبنا على دينك. آمين. فالسلام عليكم ورحمة الله وبركاته. How's everyone? Alhamdulillah Rabbil Alameen. طيب, so we continue. We're about 10 minutes behind, so we'll speed it up. The weekend. Allah Akbar. So, we're still reading Islamic Contract Law. And from the offset, we said that we drew a distinction between Islamic finance and Islamic contract law. And we said that Islamic finance is broader than Islamic contract law. So what we are busy with is with Islamic contract law, right? And Islamic contract law, very simply, has got to do with the fact that Allah subhanahu wa ta'ala has allowed us to own things. And in this ownership, Allah subhanahu wa ta'ala has made us such that we have different needs. So this requires us to transfer between ourselves the ownership of goods and the offering of services. In order for this to take place without niza', without dispute, right? And with nizam, with harmony, Allah subhanahu wa ta'ala legislated that they take place via the vehicle of contracts. So we have outlined some of these contracts, and we said that we will study one of these contracts, the conventional sales or the simple sales contract, right? And we said for two people to exchange wealth such that there is a transfer of ownership, then certain pillars must exist. And these pillars must exist in a particular way, and we call those ways conditions. So we said that the first of these pillars, or arkan, or integrals, is that of the contracting parties. There must be contracting parties. And this refers to the buyer and the seller. And then we stipulated for the contracting party certain conditions. We said that they must have unrestricted contractual capacity, and we explained what that means. We explained that there must be the absence of coercion without just cause. We said that when a buyer wants to purchase a Quran, then they must be Muslim or the like. When a seller wants to sell weapons, then he will be barred from doing so if the buyer is at war with the Muslims or belongs to such a state, right? Then we moved on and we said that just like the contracting parties can contract on their own behalf, they can do so via appointing an agent or a proxy to do that on their behalf. And we went into how the permissibility for trading via, for example, machines, via an a fortiori argument. Thereafter, we said that there must be the contracted item. And the contracted item consists of the commodity and its counter value. And the most common type of counter value would be money, right? And we stipulated some conditions for the contracted item. We said that the contracted item must first of all be pure. If it is not pure, then we will not allow its sale. When we spoke about this purity, we said that it must have taharatul ayn, that the corporeal must be pure, right? And that means that the physical entity must be pure. What if that entity is sullied with filth, right? For example, a scarf that is sullied with blood. We said that we will allow its sale. Why? Because the entity is pure, but it's sullied with filth. Then we said that it must have a manfa'a, it must have a usufruct, it must have a benefit, right? In regards to this benefit, we said that first of all, there's a tangible measure. Something must have a tangible benefit. Then we said that if the tangible benefit can only be accessed at a certain quantity, then we will make that quantity a threshold for the permission to buy that thing. For example, rice. Cannot buy or sell 1 speck of rice or 1 grain of rice as such, right? Thereafter, we said that when we have established a tangible measure that for something's utility, we will have to check whether or not the Sharia allows us to access that utility. If the Sharia allows us to access that utility, we will allow its sale. If not, then not. For example, music, right? So because the Sharia doesn't allow us to access the utility, we won't allow its sale, right? Thereafter, we said that the contracted item must be owned by the contracting party, right? Or the one on behalf of whom the contracting party is contracting, right? So it must be owned by the person who's selling it or the person who you're selling it for. Fine. Then we said that it must be possible for the contracted item to be handed over. And we said that this does not mean that the contracted item must be handed over in that contractual sitting, but it must be possible to do so. And as an example, we explained the prohibition of selling a bird that is in the sky, even if a person owns the bird. Right? What else did we say? Right? So that's with regards to the conditions. Then we mentioned the fifth condition, that it must be known. The contracted item must be known. The corporeal must be known. And when we said the corporeal must be known, right, then we said that this means that the contracting parties must see it. If this is the case, we will allow it sale. If not, then it must be described. It must be described in terms of its specifications, right, as well as its quantity. Specifications as well as its quantity, which separates it from other goods and the intent of other goods, right? So that was with regards to the conditions for the contracted item. Then we asked we looked at another type of sale, forward buying sales, and we said that when we look at most conventional sales, right, that we engage in, they are not in fact conventional sales, but rather they are forward buying sales. And we've discussed a little bit about the nature of the forward buying sale, what are some of the core elements, and based on that, we spoke about the permissibility of the likes of take a lot and وما إلى ذلك من الأمثال. Thereafter, we ask ourselves the question that is it possible for the contracted item to be a usufruct and not a corporeal? And we established that if this is the case, and it takes place permanently, then we will allow its sale, and it will be a conventional sales contract. For example, if a person has the right to use a passage, that's a usufruct, it's a utility, right? They can sell that utility to the neighbor so that the neighbor can have exclusive right to use that passage, as an example. Then we said if there is a temporary sale of the usufruct, this will be facilitated via a different contract, and we'll call it hiring, right? And that will have its own specifications. Thereafter, we asked ourselves another question, or rather we presented a different example, and that is when the contracted item is usurious. And that's where we are now, when the contracted item is usurious. And what did we say in this regard? In this regard, we said that it is established via the prophetic narration that there are 6 categories of usurious commodities. These 6 categories can be put in 2 groups. In group 1, we put gold and silver. In group 2, we put grain, wheat, rice, and dates, right? And we said that if you are trading within a specific group, right, and you are trading the same one category for another item in that same category, then 3 conditions will apply. It must be cash. The items must be exchanged in the contractual sitting, and there can be no discrepancy in amount. For example, 5 grams of gold for 5 grams of gold, a cash sale, not deferred, and it must be exchanged in that sitting, right? The same would apply with another category, within another category. Then we said that if I am selling one category for another category within the same group, for example, gold for silver, then only 2 conditions will apply. It must be cash, not credit, and the handing over must take place immediately, right? So there can be a discrepancy in amount. For example, 10 grams of gold for 20 grams of silver, right? Which you wouldn't do, but That's an example, right? Thereafter, we ask ourselves, is or are usurious commodities confined to these six categories that are mentioned in the hadith, or can we extend them to other commodities? So we said that when we look at them, they have a clear ratio legis. They have a clear shared descriptive quality that is the reason for them being usurious. Over here, we found it was foodstuffs in group number 2, and over here, we found that it was currencies. So whatever we found to be currencies, we would give the same ruling in terms of riba and the manner in which it must be traded. And whatever we found to be foodstuffs, we will, or staple food rather, we will join in that ruling. And that's what we discussed thus far. Okay. One day I'm going to have to stop giving a summary because it's going to end up taking the whole class. Okay. So, glass of water will be nice. So, what did we want to say? The next discussion will be our author over here, Ml Muhammad Carr, speaks about the importance and the role of usury in sales. So for this, I'm going to read through the text and it will be self-explanatory, inshallah, but it's an important point that Mawla is making. Before we move on from this discussion to what follows, our honorable student, allow me to, we are on page number 42, allow me to direct your attention to two important matters. Number one, usury is divided into two types. Usury in sales, and that's what we've been discussing now, and usury in loans, right? Which has a chapter on its own. So usury in loans is discussed in the chapter of loans. Usury in sales is like a subcategory of usury that we discuss in conventional sales. The explanation of usury in loans will be presented when discussing loans, Allah willingly. We won't discuss it in this class. Over here, you have seen one application of usury in sales in the form of selling one currency for another. You also notice that this type of sale actually occurs, and its occurrence has great significance and extreme danger in relation to the conditions set out by the Messenger sallallahu alaihi wasallam. Mala means thereby that this is a very common type of sale, and you can see how easily a person is prone to usury. For example, this happens to me in the school. A student comes to me with 100 rands, and he says to me, "Mala, do you have change?" Right? And then I take out a bunch of 20 rands from my pocket, and I ask him, "How do you want it?" Right? And I give him the change. And so he gives me the money, and he wants to make a run upstairs quickly. I tell him, no. That's usury. You have to sit here and take this money now. Right? So it's a simple example, but very widespread. Isn't it so? You go, for example, you go to the shop, you go to the garage, you tell the person, "Give me 100 rand change, go back to your car." Right? You leave the contractual setting. You come back, that will be usury. Very simple. You understand? فَلْيَتَنَبَّأَ الْإِنسَانِ. Let the person be cognizant of these conditions because they are very common and they are very important. Right? Secondly, our honorable student, this case of selling gold for silver, with its preconditions of being that comma is supposed to be before the with. Yeah, that's my fault. Secondly, honorable student, this case of selling gold for silver, with its preconditions of being cash and hand-to-hand, holds within it the secret to prohibition of usury in sales. It is closing the door to usury in loans. That is to say, usury in sales closes the door to usury in loans. This is explained by the fact that one who consumes usury, instead of doing so in the form of a loan, turns to a loophole which he finds in the form of sales. So he sells rands for reals on credit. On this account, credit has been prescribed and the condition of cash stipulated to close the store. Right? So the usury in loans is that I tell you, look, I have a fungible item, right? Like this phone is a fungible item. So I tell you that I will give this phone to you as a loan, not borrow it, not lend it, right? Not hire it, but loan it, right? That means that I am giving you this phone, and you must give me another phone like this. So you say, okay, no problem. But when you give me another phone like this, just give me extra 10 rand. There you have an example of usury in loans. Usury in loans. So now the door of usury in loans is closed. So what does a person say? He says, you know what? I'll sell you 10 rands now for 20 rands later. I'll sell you 10 rands now for 20 rands later. So now it's not a loan contract, it's a sales contract. But the same thing is achieved. So usury in sales has been prohibited because it's a door into usury in loans. Right? Because it's a door into usury in loans. There's more examples of that, but we won't flesh it out too much. Our honorable student, all religions have prescribed usury in loans. The proof for this in relation to the people of the book is Allah's word saying, وأخذهم الربا وقد نهوا عنه وأكلهم أموال الناس بالباطل وأعتدنا للكافرين منهم عذابا أليما. Says that, and they're taking usury, though indeed they were forbidden. Oh, that was a Zakir Naik moment. Yeah, converted the Arabic to the English to Arabic. You saw what I did there? Yeah. I do that sometimes. And they're taking usury, though indeed they were forbidden it. And they're devouring the property of people falsely. And we have prepared for the unbelievers from among them a painful chastisement. So this is in relation to the people of the book. There's an interesting article in this regard that you can read. It's quite informative. Who writes the article on usury? Very famous article. Macintosh. You can just type in prohibition of usury, Macintosh, PDF. You'll find it, right? And over there, he speaks about how usury, interest, has been haram in all the previous religions. In all the previously the religions. Thereafter, Islam came and also prescribed it, right? So, if the people of the book had to follow the very Jews that make the banks, if they had to follow their own law, right, then they would have been more in need of Islamic finance than us. Because it's well known to everyone that Jewish law is more stringent than Islamic law, if they had to practice it. Right? So, the people come to us and they say, oh, it's so difficult, this way, that way. That's supposed to be, they also, according to their own book, they're also falling into haram. It's not like it's halal for them and it's haram for us. So we look onto them, oh, they can play in the park, we can't play in the park. They also prohibited from playing in the park. Except that they disobedient students and you obedient students. Except that they disobedient worshippers and you, in fact, they're not really worshippers, but let's say if they were worshippers, they would have been disobedient worshippers and you obedient worshippers. That's the only difference. It's not allowed for them. Right? And one of the ways that they changed this law was to say that we cannot give usury, but we can take usury. So we say that we don't give riba, but we can take riba. You understand that? Now the Muslims say we don't take riba, but we give riba. So what's the difference between you and the Jews? Not you. You guys don't take riba. But what's the difference between this type of believer and the Jews? Nothing. Nothing. Right? Difference. So may Allah protect us from this. Thereafter, Islam came and also prescribed it. However, it did more and closed the door to usury by prescribing usury in sales. So, all praise is due to Allah who has completed for us our way of life, perfected His favor upon us, and chose for us Islam as a way of life. Right? Okay. So now we move on to the sale of jewelry. We're still in the chapter of usury, but now we're going to speak about jewelry. So, gold and silver are usurious commodities, right? As we have seen according to the text, right? According to the ahadith of the Prophet sallallahu alaihi wasallam, right? So, no matter what form it takes, whether it's a nugget, whether it is a minted coin, whether it's a broken minted coin, whether it's a complete minted coin, or whether it has been manufactured into jewelry, the laws of usury are never detached from it. As long as something is gold, as long as something is silver, right? In whatever form you turn it into, or whatever shape it takes, the laws of usury will still apply to it, right? So he says that nowadays one mostly buys jewelry made of gold or silver with currency. And currency, yarhamukallah, and currency is also a usurious commodity. You think about that? We buy gold and silver jewelry with currency. And currency is a usurious commodity. Not by explicit mention in the textual evidences, but by giving currency the ruling of gold and silver, because currency shares a ratio legis with gold and silver. And that is the fact that it's a counter value. Right? The fact that it's thamaniya, moneyness. Right? So gold and silver and fiat money, which is the paper money that we use in the form of rands, euros, and dollars, they share with gold in the same reason or in the same quality, and that's the fact that it's money, that it's currency. So, if we exchange gold and silver for money, meaning that we buy gold and silver with money in the form of nuggets, in the form of coins, or in the form of jewelry, then the laws of usury will apply. And how many laws will apply? 2 or 3? Okay, who says 2? Who says 3? Well, the rest of you are undecided. Right? So we said that group 1, gold, silver. Group 2, wheat, grain, rice, and dates. Right? So where are we working? Group 1. So is it one category for one category? Remember, we extended this. So you have gold, silver, rands, dollars, euros, pounds. So what are we now selling? We're selling currency for currency. Is it the same group for the same group? Or yes. Is it the same category for the same category? No. It's 2 different categories. Because each currency will now become its own category. You understand that? Each currency will become its own category. So like gold is a category, silver is a category, rands is a category, dollars is a category. You understand that? So if I sell rands for rands, 3 laws apply. If I sell rands for dollars, 2 laws apply. So what if I sell rands for gold jewelry? 2. You got that? طيب. So what are those 2? Can the amounts be different? Yes, the amounts can be different, right? However, it must be an hand-to-hand exchange. That must be cash. It must be cash, not credit. And remember what we meant when we said cash here is that you must pay now. That you must pay now. طيب. So, accordingly, it is not permissible for you to buy jewelry at a credit price, such that you take possession of the jewelry at the point of sale and hand over the counter value at a later stage. Don't worry, we have a solution. Right? So, as for the case where you do not take possession of the jewelry, but rather you make an agreement with the seller to buy the jewelry, then you store the jewelry with the seller until you pay for it via installments. Is this permissible or not? So you call this lay-by. So you lay-by the jewelry, right? So what do you do in the lay-by? I'm not going to read all Maulana's notes. I'm just going to tell you what he says, right? That at the inception, you're not actually engaging in a sale. You're making a promise to buy. As a show of your commitment and your seriousness in that promise, you put something down. And you keep coming back to put more down, right? As an increased show of your commitment. And he still has the jewelry. Isn't it so? He still has the jewelry. But what does he do? He makes you a promise on the other end. What does he promise you? He promises you that you won't sell it. Right? So he'll keep your money for you. He'll keep your money for you. And he'll keep the jewelry also. Right? Then, when you make the last payment, right? Not actually payment, but when you give him the last installment, right? Then he has the whole price with him. At that point, you engage in the sale, right? Then you get your slip and whatever, right? And at that point, you engage in the contract, and now you take the jewelry. So in the beginning, it started out as a promise to buy and a promise to sell, and you kept that commitment by him keeping the jewelry for you, and you kept your commitment by giving him amounts to keep for you, to store for you, so that the time when the entire amount is gathered with him, then you'll engage in the sale and you'll take it at that point. And so what looks like it shouldn't be permissible over here, we'll construe the sale as being permissible, and all the conditions having been met. Right? Make sense?
You have to have it with him, the final installment. It cannot be stored elsewhere.
The jewelry.
The jeweler. So that commodity, when you come here, they give a final installment.
Then he has to give it to you at that point.
At that point.
He has to give it to you at that point. Right? Which is not a difficult thing.
Does he have the right to change his price in the meantime?
No. He can actually. I changed my mind. Right? We'll answer more questions at the end of the class, okay? Time. So that point is clear. There's another problem. Right? The stipulation of hand-to-hand exchange. Usually the buyer takes possession of the jewelry, taking it from the seller during the contractual sitting. So accordingly, there's no need to discuss the taking possession of the contract item of jewelry in most cases. So in most cases, commonly when people buy jewelry, the jewelry will be in the store, right? And as long as you are together in that space, the store is kind of the contractual setting. As long as you are in that store together, and he goes, he fetches it, and so forth, you consider to be in the contractual setting. You don't have to be with one another all the time. You can even, for example, you can even walk together to the car. You would still be in the contractual setting. So the contractual setting is not the place. It's the fact that you consider to be together in the same place. You understand that? So if normatively we would consider you to have separated, then that will be considered the separation. There's no known distance. Right? How do we know this? We're going to see this when we discuss Majlisul Khiyarul Majlis, the option to terminate whilst in the contractual setting. That the person can be halfway across the world and you can still be considered to be in the contractual setting. And we'll explain how that works when we get there. So we said we don't have to discuss the hand-to-hand. That's quite clear. Or the taking position as such. However, the buyer plays his role by paying the price. So sometimes the person comes and there's different ways for them to pay. Right? So if the person pays with the money, there's no doubt about that. With physical cash money. But then the person swipes his card. So he goes to buy jewelry, he swipes his card. And these transactions are of different natures. Sometimes it can be that when the person swipes their card, then the one party is FNB and the other party is FNB. So there will be an immediate exchange, right? The money will be taken out of your account and it will reflect immediately in the next person's account, right? And there will be the capacity to use it. So we don't have any problem with that, right? That's called a constructive payment. So constructive payment in the sense that it's a new method of paying and we consider it to be a type of physical handing over. Why? Because both parties have immediate access to the funds and they can use it in that immediate moment. So it is cash, not physically, but constructively, right? Then you have another case. And this case is where the banks differ. So now you're going to have that period wherein, let's say, for example, you have an FNB account, right? And you have a balance and you have available. Isn't it so? You have balance and you have available. So your balance is what you can spend. No, your balance is what you have. And available is what you can spend. So sometimes it may be that you make a payment, you make a payment, right? And your balance doesn't change, but what you have available changes. Meaning what? You pay 2,000 Rand, but because it's pending, it doesn't yet reflect on your balance. Similarly, you might receive 2,000 Rands, right? And it reflects in your balance, but it's not yet available. Why? Because there's a period wherein there's a delay in transfer on account of differing banks. And that period can differ according to the financial service provider that you're using. So over here, there should be a case of delay in payment. There's a big yowl loss. There will be a delay in payment. Right? And he says, if any form of delay arises during the exchange of usurious commodities, the transaction is invalid. Right? However, certain contemporary scholars hold the opinion that delays in bank transactions which occur in a manner where the buyer is considered to have made an immediate payment at the time of purchase, as per customary shopping norms, are overlooked. Nevertheless, it is impermissible for the buyer to deplete the funds in their account during this period, referring to the delay in bank transfer until the buyer is able to practically access the funds upon their reflection in the buyer's account. You understand what that means? I'll explain it to you. So, there are certain contemporary scholars that have given a fatwa on this issue. And they said that in this type of constructive payment, where there's an unavoidable delay, there's an unavoidable delay in bank transfers, they will overlook that delay. Why? Because if I have a debit card or a credit card, but let's give example of a debit card, and I go and swipe that card, as long as that transaction is accepted in the store, they will allow me to leave with the goods, whether or not it has reflected by them. They don't wait to check that. So, according to the norms of shopping, even though there's a period wherein the money is not yet reflected on the buyer's account, the buyer will consider that to be a cash payment and they will allow you to leave the store. Therefore, we will construe that as a cash payment. However, they will stipulate in addition to this that because you can run into, I think they call it the overdraft, right? Where you end up spending more than you have. In that period where, for example, you spent 2,000 rands, right? And that transfer is pending. You will not be allowed to spend such that you have less than 2,000 rands in your account until that money has been cleared. You got that? So that's the ruling.
So you can still spend more money. You want to win overall.
I'm not saying that you cannot. I'm not saying that you cannot do it practically. I'm saying that we, in this ruling, it's a good observation. What he's saying is that you can spend more, and I am agreeing that you can. But over here, we are stipulating that you cannot. You understand that? So the fatwa has two parts. The one part of the fatwa is that if they will allow you to walk out of the shop via swiping, then that's a cash payment. The second part of it is that for that cash payment to be real, you will have to have that amount of money in your account to square it until the time that the payment has really reflected. Right? So they will bar you, meaning the Sharia will bar you from spending more, according to this fatwa, until such time that it's cleared. Right? So that's a responsible view.
No. You buy say you got 20,000 clear, a sporting account, go to American Express, owned by TFG, Same. It's immediate transfer, but it's credit.
Okay. So I've said this in the previous lesson and I will say it again. What we mean by credit is that the payment takes place later, not that you are using a credit card. A credit card is a cash payment. You understand that? Why? Because you do not have credit with the person from whom you are buying. You have credit with your financial services provider. So the word credit in the credit card doesn't mean that you are using it for credit sales or credit purchases. It means that you are making cash purchases and you are running up credit with somebody who's squaring those purchases for you in that time. So credit is from the perspective of the credit card holder and the financial services provider, and not from the perspective of the credit card user and the seller. Is that point clear? So when we say credit in relation to usury, we are not referring to the credit card, or rather we are referring to the delay in payment, such that the payment does not take place in that contractual setting. Is that understood? Type. It's a good question and an important point. Okay. So we'll end off this chapter by
What if a lady agrees to a marriage and says, I agree to the marriage, but one day you must take me on Hajj?
Okay, that's. I won't answer that question respectfully because we're in a different chapter, right? So you can ask it when all the questions are finished for this for Islamic contract law, and then at the end, inshallah, you can bring the question again, and then we'll discuss it. Inshallah. Right? So for the last we will read. Manla says, what is safer, O noble student, is that you try as best you can to choose a payment method which guarantees that the money will reach the seller before you leave the contractual setting. Before moving on from this matter, O noble student, let me inform you of another perspective regarding it. So in his book, أحكام البيع والشراء أحكام بيع وشراء حلي الذهب والفضة, on page number 46, in our book, Yunus Rafiq al-Misri says, on the other hand, there are other views which oppose that of great scholars, such as that of, meaning these views oppose great scholars. Whose views are these that oppose great scholars? Such as that of Ibn Taymiyyah and Imam Ibn al-Qayyim, who both opine that differing quantities in the sale of gold for gold or silver for silver due to production or manufacturing is permitted. So what are they saying? They're saying that if you take 50 grams of gold and you turn it into a ring, right? And you take a 50-gram gold coin, right? Then you can exchange. Or you have a 100-gram gold coin. Then you can exchange one for the other, even though they're both gold, right? Why? We'll come to see. They also permit delay. That is, they permit credit sales. This is because permissible gold becomes a commodity through production. So, on the view of Ibn Taymiyyah and Ibn al-Qayyim al-Jawzi, what do they say? That when you turn gold into jewelry, it's no longer gold. It's a commodity. Therefore, you're not trading currency for currency, you're trading a commodity for currency. So they will allow a discrepancy in amount, and they will allow credit sales. It is thus no longer considered as currency. Hence, the laws of usury do not apply when it is exchanged for a price represented by currency. Differing quantities and credit is thus allowed. This operation thus no longer has any distinguishing usurious traits. You are therefore transacting as you would with any normal monetary transaction, confined to the general laws of fiqh, of jurisprudence. It is clear that the opinion held by Ibn Taymiyyah and Ibn al-Qayyim from the early 8th Hijri century delivers great ease to those Muslims who trade in gold and silver, taking them out of much stress, difficulty, and seeking loopholes. Additionally, they would not have to flee from this field of business, leaving others to benefit in exclusion of themselves. Furthermore, the door of loans is not closed upon them, which is a source of great difficulty, as mentioned by Ibn al-Qayyim. If these two great Imams had issued this fatwa 700 years ago, then undoubtedly the traders of jewelry are in greater need of this verdict today. Owing to the passing of time and the change of settings, as well as methods of trading. And though these views fall out of the ambit of the majority of scholars, they do have a valid legal leg to stand on. It is also important to mention that the view of Ibn Taymiyyah and Ibn al-Qayyim has legal precedents dating back to the earlier generations, the Salaf. It is a view held by Al-Hasan, that is Al-Hasan al-Basri, Ibrahim al-Nakha'i, and Ibn al-Sha'bi, right? Who have expressed that they permit difference in quantity in the case of manufacturing, right? When gold becomes jewelry, then they permit difference. The view of Muawiyah ibn Abu Sufyan and Hassan al-Basri indicate that they both permit difference in quantity as well as credit. Still, we encourage those trading in gold and silver to practice on the more cautious opinion in as much as they can. This is because avoiding areas of difference of opinion between scholars and practicing on the opinion of majority scholars or on the opinion of the majority is better, right? So there you have an alternative view, but still it doesn't cover Forex, right? Because Forex is not jewelry. طيب. So what follows, inshallah, is the formula. Once we're done with the formula, then we'll give the definition of the sale. I don't know if you noticed that we didn't define the sale in all of this time. Right? So it will benefit you to have the definition at the end, because all of these ma'lumat, all of these pieces of information will, inshallah, come together. Once we are done with that, how many classes are left? 3. Possibly 3. Okay. So what we'll endeavor to do in the next class is complete the formula, which is quite simple. Then we'll go on to defining the sale, and then we'll get into different types of sales. And we'll start explaining murabaha. So we'll give an example of home financing and how exactly that takes place. We'll deal with some objections in relation to that model, and then we'll complete the 1 class with that. And then we'll get into khiyar and so forth. Hopefully we can complete in the next, inshallah, 2 days, maybe 3. بهذا نكتفي وصلى الله على سيدنا محمد وعلى آله وصحبه وسلم والحمد لله رب العالمين. Shall we open for questions about the topic first? Alaikum salam wa rahmatullah. Yeah, so you would have to make the payment physically and collect it physically. Right. So in the case where you make an EFT now and you fetch it later, it's going to be considered riba. Allah knows best. Right. So the best thing that you can do is to pay at the time, and it's not difficult. There's no need for you to pay earlier. Why? Because we have allowed the delay in terms of the transfer. You understand that? So you can avoid that situation altogether by paying. Nowadays you can do geo payments. The person is in front of you. There's so many ways for you to pay immediately, and whilst the person is in front of you. So we advise you with that, and we say that the situation that you have described, where you pay first and you collect later, be considered as riba. Right.
If it's a piece of jewelry, and in order for the sale to proceed from the buyer's perspective, he's she says that I require a percentage as a deposit in order for me to begin starting to prepare the piece of jewelry.
That's why we come.
And then does it become sort of like a, so the question is that, what if the jewelry must still be made and the person requires a deposit, right? We like we said, in the case of we haven't made a payment, then we can construe this as a promise to purchase, and they sort of storing it with you. That is what we've construed it as. And so, in the same way, we didn't take issue with it over there, we wouldn't take issue with it over here, and Allah knows best, right? So you make the actual payment when you collect the jewelry. You can go completely outside of this and go with the view of Ibn Taymiyyah and Ibn al-Qayyim, and then you have manufacturing of jewelry, and it wouldn't be an issue. All right, but inshallah, either way, it would be acceptable as long as you make the final payment physically and you take the jewelry physically. Allah knows best.
It's kind of off, but it's kind of like just for buying. I'm just thinking. Say, for example, I'm Joburg, for example, and guy's cutting, or he's got the jewelry taped out. Because of my time, I'm going to be busy now traveling. I send him the money. He clears in his account. By the time I land, can I give the value of a POP as payment? So he's got the money in his account, but we're saying this POP serves as the value for 20,000 maybe, and then exchange takes place in money transfer. The money's in his account maybe a day, maybe. He's just the honest guy, you know that. This POP now has the value of it. Even though it's just a piece of paper printed, like can we attach the value to that piece of paper as a payment?
No.
No.
The question is that, can you pay in advance and then bring the proof of purchase and construe the handing over of the proof of purchase as a payment to avoid riba? No. Right. No, over here, we're only speaking about usurious commodities. Right? So if that were to be a cell phone, we would have no problem with it. Yes, half of front, half later. You could pay the whole thing later. You could pay the whole thing up front. No problem. Like we said, according to the view of Ibn Taymiyyah, the laws of riba doesn't apply in relation to jewelry, because through manufacturing, they consider it now a commodity, right? A product and not a currency. You understand it? No. Yeah, any type of manufacturing. So the question is that, what if it was just melted down and made into a statue that you worship? That would be haram, right? If you made it into an ornament, for example, it would, according to Ibn Taymiyyah, it will take the same ruling. Why? Because it has been manufactured, right? Yeah, the online purchasing of jewelry is problematic. What happens is that, it's difficult to construe it as a non-usurious sale. It's difficult to construe it as a non-usurious sale. Allah knows best. I have one configuration, but it's not quite like apt. I'm not very comfortable with it. Muhammad? It only applies to gold and silver jewelry. So we won't take platinum, we won't take, I don't know what else there is. No, diamonds is not currency. Diamonds are forever, but they're not currency. Right? Diamonds are not currency. So we're only referring to gold and silver.
Bigger buying. Because legally they have to keep it for a few days before they can buy it.
Yeah, that is in recognition of this. In recognition of this, we read the fatwa of Ibn Taymiyyah and Ibn al-Qayyim. That already at that time, when people were purchasing jewelry and that in large amounts, then uh, there would be like a sort of normative delay just for market. For example, you now have to verify a big amount of gold and all of those type of things. So in view of that, Maulana has mentioned the fatwa of Ibn Taymiyyah and Ibn al-Qayyim that when it comes to trading on this scale, then these are unavoidable differences. And he presented this fatwa. If a person can avoid it, they should avoid it. And if not, but what is clear from here is that Maulana intends us to practice on this view, to construe jewelry as a commodity and not as a currency. And normatively in any market, we don't consider jewelry in whatever form to be currency. We consider it to be a commodity for trade, right? So in view of these things, Maulana has presented this fatwa that comes in the book of Yunus Rafiq al-Misri, and he intends thereby that we practice it, right? Allah knows best. طيب. The last question was about Mahr. About Mahr, right? Okay, so the question is clear. Okay, excellent. طيب. And in that case, inshallah, we suffice for that. وصلى الله على سيدنا محمد وعلى آله وصحبه وسلم.